When can law affect the development and course of artificial intelligence? One of the big areas of law that apply in the artificial intelligence space is copyright law. Copyright law allows creators of artistic works or other creative expressions to get protection for those works that prevent other people from reproducing it, distributing it, or creating derivative works without their consent. One of the issues that arises in AI is it a copyright infringement for companies to use copyrighted content to train AI models? Many of the companies that are engaged in training data using copyrighted content say that this is a fair use because they are transforming the nature and character of the original creative work, like an image or a text file. Whereas those on the other side, the creators, say that this is in fact a reproduction and that many of the outputs of AI data are exactly equivalent to the inputs that were the copyrighted content. So who's right? It'll be very difficult for judges to determine, but there are a number of cases right now, especially against OpenAI, that are trying to determine whether it is a copyright infringement to engage in AI training, and also under what circumstances. Will it be a copyright infringement or potentially an indirect copyright liability if the outputs from AI are substantially similar to copyrighted content? So a person can be liable, or an entity can be liable, for an indirect copyright infringement claim if they control and profit from the infringement of another. That can be difficult to show in an environment like use of AI. And specifically, it's important to know that courts have held that without knowledge of specific acts of infringement, companies ordinarily are not liable under this contributory infringement theory. Now, another concern could be that perhaps training in AI is going to constitute copyright infringement because there's reproductions, the people that are creating content allege. But we'll have to wait and see what courts determine on fair use and if they determine that there is in fact a reproduction taking place at all. Those are going to be the big questions in the lawsuits coming up. Now, another area where copyright law affects AI and AI affects copyright is in the space of eligibility of works that are created with AI. So right now, the Copyright Office has taken the position that works generated with the assistance of AI, like Midjourney, are not protectable unless there is substantial human involvement in the creation and you're just using AI, for example, as an editing tool like Photoshop. And that's going to be a big question that also will come up to courts. Now, the Copyright Office has made that determination, but we don't know if courts are going to go the same way. And courts are in fact entitled to reach a different conclusion than the Copyright Office. We'll have to wait and see when some of these decisions get appealed. Are courts going to take the same view as the Copyright Office and hold that AI-generated works are not eligible for copyright protection because they are not the creative work of a human being? They're not an original work of authorship. That's generally the main concern when it comes to eligibility there. Some other areas where the law is going to affect AI development is in the patent space. There's a huge concern that perhaps items that are generated with the help of artificial intelligence might not meet the standard of eligibility under the Patent Act. Another legal issue that can arise in the AI space is patent law. Patent law does not protect abstract ideas or algorithms. So sometimes inventions in the AI space might fail to meet this subject matter eligibility requirement of patent law because the invention is sufficiently abstract and it fails to have any other element to the invention to bring it out past just a routine or conventional expansion on that abstract idea or fundamental concept. So for example, someone who invents the telegraph cannot patent the idea of communicating using electronic waves. Similarly, someone who develops the first machine that is able to use generative technology might need to be careful to make sure that when they're phrasing their patent claims, They're not merely claiming abstract ideas by doing so. That's going to be a big challenge in the AI space. The biggest area where I see law impacting AI and AI impacting law is in the space of deepfakes and right of publicity. So, right of publicity protects against misappropriation of someone's name, image, or likeness for commercial purposes without their consent. This is the rule in most states, although every state has a different right of publicity law. It's not a federal right now. I do think that we should have federal protections to help make the law more consistent from state to state, and also to potentially add new protections to address some unique harms that can arise because of AI. So specifically, most right of publicity laws do not have the ability to protect against non-consensual deepfake pornography. And this is because many times this is not a commercial misappropriation of name or likeness. Now, sometimes this can be protected under other areas of law, like privacy violations. There's something called false light, which is a tort of depicting a person in a way that is not consistent with their actual image or self or practices. So one of the classic cases here is where a billboard was showing a stock model as the face of an HIV survivor. And that model did not like being depicted that way and did not give consent to be depicted that way, even though she was a stock photography model. And so the court said, yes, that is depicting her in a false light, and it could harm her because people who see the image would assume that she has an HIV positive diagnosis that she did not have. A similar thing can arise in the context of deepfakes if deepfakes are used to show somebody in a false light. But if you are not reaching that boundary of false light law, there may still be a lot of contexts where you would not want your image to be used, but you can't say that it's a false light, and you can't say that it was a commercial misappropriation, and so you're left without a remedy. This can be really difficult to an individual emotionally, and they might feel like the law is not protecting their interests in their own face and privacy. I think that in light of the proliferation of deepfake technology, we should have a federal right of publicity. If you'd like to learn more about the relationship between deepfakes and the right of publicity, I encourage you to check out my blog post on the topic, co-authored with Eric Goldman, who has a very different view than I have. That article is called Deepfakes, Freedom of Speech and the Right of Privacy, and it's available on my blog and also on Cleveland State University's Your Witness blog. I hope you check it out.